Our next speaker is Eric Hirschhorn. Eric is Undersecretary for Industry and Security at the Commerce Department. He's been there for 2 years, but boy, is he no stranger to this area of policy and law. He joined the administration from the law firm of Winston & Straw. He's the author of an Export Control and Embargo Handbook in the 3rd edition. He previously served as Deputy Assistant Secretary for Export Administration, and he was the Executive Secretary of the Industry Coalition for Tech Transfer, which I had the pleasure of helping run and being involved with, going back many years. He's a longtime veteran of export control debate in the Carter administration, where we worked together. The export controls are something which at different points in time in our industry's history have been immensely important. And then to some extent, some of the problems got fixed for a while, and it faded a little bit, but has always remained important in many ways. And now we have a new era, new technologies, new issues, new foreign policy type control challenges. It was only within the last week that there was an announcement with regard to sanctions because related to internet technology being used to internet control for, I think it was Iran and Syria. So the issues are alive. We have a tremendous issue that's been discussed by many speakers here about internet freedom, and to the extent the administration is going to use some of its tools and power in this area, we can both applaud it and worry about it, because if not done with the right hand and nuance, it could become a problem for us, as export controls sometimes have. At the same time, it could be a great tool to keep the internet open more so. So with that, let me welcome a longtime friend, Eric Hirschhorn, and have at him.
Thank you, Ed, and thank you all for your interest in what sometimes is an arcane subject. Although I think, as Ed would agree, when he and I started in the export control field probably 25 years ago, it was a lot more arcane. In fact, not long ago, I did a webinar for the customs brokers and freight forwarders, and there you don't have the benefit of a live audience, which I very much prefer, but you have, you're just sitting in a conference room with a screen, and there is a counter that tells you how many phone lines are open, and they had about 350 phone lines open. And they told me they estimate 3 people per phone line, which perhaps is generous. But when I got home that day, I said to my wife of 30 years, so she's followed sort of export controls during that time, I spoke to 1,000 people today. And she kind of looked at me and she said, about export controls? So I do appreciate your willingness to sit still for this. It is important, and it's important to you too. And it is a pleasure to be here to talk about the President's Export Control Reform Initiative. Before I kind of get into the weeds, I think we all recognize that there's still a great deal to do to restore our economy. And the President's State of the Union address in January provided a blueprint for that. Export control reform, above all, is a national security initiative. But it will have the happy incidental benefit of helping make the President's blueprint a reality. It's a common sense approach to overhauling a system that is based on 40-year-old Cold War era authorities and standards, and was designed to address the challenges of a Cold War world. So about 2.5 years ago, the President announced the Export Control Reform Initiative to update the system to one that addresses today's national security imperatives. I sometimes say that if the President had realized how long it would take, he might have said, maybe not. But the amazing thing about export control reform is very much like Dr. Johnson's line about a dog walking on its hind legs. The amazing thing is not how well it's being done, or in our case, we think it is being done well, how quickly it's being done, but that it's happening at all. Anyone who's followed this field for a while, I think, will agree that change is extraordinarily hard in the export control area. Now, why do we need to reform this area? It's a very coagulated system for lots of reasons. And what we hope to do with this reform and expect to do with this reform is help us to focus our very limited resources and the limited resources of the exporting community on the threats that matter the most. Right now, the State Department licenses about 85,000 cases a year. We license about 25,000. Between 2/3 and 3/4 of what state licenses as defense articles are things like bolts, small parts, small subassemblies, components, and a relatively small proportion is the kind of end items that you would imagine when you think of defense articles. So reducing the number of items that require those kinds of licenses will help us focus our limited resources on the threats that matter most. Today, just as an example, and if you take a bolt from Stroh-Snyder's, the local hardware store, and you shave 1/8 of an inch off it because it needs to go into, let's say, an F-18 fighter aircraft, that bolt is then specially designed or modified for a defense article, and it is then subject to the same controls, the same restrictions, the same licensing regime as the F-18 itself. It's a little cuckoo, and it's not just an academic problem. Again, it forces us to spread our resources far too thinly. It plays hob with interoperability. Secretary of Defense Gates used to tell the story of a C-130 cargo aircraft that sat on a runway in Australia for 2 months when it was needed for coalition forces because it was awaiting a parts license from the Department of State. As someone has put it, if you sell someone the elephant, why not let them have the peanuts? Another problem that we're trying to resolve, and again, the F-18 Bolt is an example of it, is what's called the designing out problem. If you Google the phrase ITAR-free, ITAR being the International Traffic in Arms Regulations, which is the State Department's controls on munitions, if you Google it, you will get lots of ads from foreign manufacturers, typically in Europe, with the very top line being ITAR-free. We promise that the goods we make as finished goods don't have any parts controlled by the U.S. Department of State. And the reason for that is that the Department of State has something called the see-through rule for parts and components, even the tiniest parts and components. Let's go back to our F-18 bolt. If for some reason you were going to use that bolt, you like the length of it, let's say. But again, it's 1/8 of an inch shorter than the one that you'd buy at Stroh-Snyder's. If you like that bolt and it's just the thing you need for your Airbus, and you put it into your Airbus manufactured in Europe, the U.S. government takes the position that the entire Airbus now is subject to the U.S. munitions list and the International Traffic in Arms Regulations. So guess what happens next? Nobody buys our stuff. And that's the designing out problem. I spoke at a conference in Toronto at the end of January, and the speaker who followed me, and I had to sit and look pleasant through his entire speech, was a representative of a large Canadian company who spent his entire time explaining to his Canadian colleagues how to avoid the see-through rule. So what did he say? Don't buy any parts from the United States. Don't buy any components from the United States. Don't hire U.S. engineers. Don't have your products tested in the United States. Don't even have your manuals printed in the United States. No surprise that this kind of attitude on the part of foreign manufacturers is hurting our sales, hurting our defense industrial base. And it's also a problem from the Defense Department standpoint, because when you add this designing out problem to the shrinking defense budget, there's a real worry about how well our defense industrial base is going to survive and how much it's going to flourish. And there's a real concern at Defense about whether the time will come when they need parts for our military equipment and can't get them in this country. And then are at the mercy of some other country whose leader is having a bad day and says, no, we won't, no parts for the U.S. this year. I think none of us wants to be in that position. And that's part of why export control reform is, at bottom, a national security initiative. It also will ease the licensing burden on exporters. That in turn will help promote manufacturing and create jobs. The State Department issues about, these figures are all, the current figures are not tentative, but the figures I'm going to project for you are tentative. The State Department now issues about 85,000 licenses a year. We estimate that probably 50 to 55,000 of those licenses will no longer be issued by state. And when the items coming from state, and it's tens of thousands of almost all parts and components, come to Commerce, we will not then turn around and issue the same number of licenses for a number of reasons. We will probably issue in the neighborhood of 30,000 additional licenses. But there are a great number of reasons why we will not issue as many as state is issuing today. For one thing, I've already pointed out the see-through rule, which doesn't apply at on the commerce side of the ledger. We have a de minimis rule that states that if 25% or less of the foreign product is U.S. content, the U.S. government does not control that foreign product, does not purport to control re-exports or exports of the foreign finished product. So that's one thing. A second thing is that we have a new license exception called License Exception Strategic Trade Authorization. It was issued last June. And under that exception, the parts and components, not the end items, that come over to Commerce from the State Department as part of this transfer that we're working on, will be able to go to the governments of 36 countries who are our allies and friends and partners without a license. There will be substantial record keeping, but they will not have to come in for a license in advance. These are all countries, by the way, that either are members of NATO or members of all four of the multilateral control regimes for export controls. There's the Australia Group, which controls chemicals, the Nuclear Suppliers Group, the Missile Technology Control Regime, and the Wassenaar Arrangement, which is sort of general national security level control. So these are not countries picked at random, but they are definitely 36 countries that share our views on world security and share our views on what ought to be controlled. One of the first things we did in export control reform was issue in June 2010 a new set of encryption rules in the Export Administration regulations. These amendments streamlined some of the controls on electronic items and enhanced national security in so doing by getting us the information we need as the government in the format we need it, but at the same time reducing or eliminating review and reporting requirements for many more items that otherwise would be controlled. We're currently focused on making a number of important changes to the U.S. munitions list and the Commerce Control List. Part of the reason that state issues 85,000 licenses a year is that they have a list that is not always specific about what's controlled. To take the aircraft category as an example, you might have paragraph A, military fighter aircraft, paragraph B, military cargo aircraft, paragraph C, military trainer aircraft, and then paragraph D, all parts, components, accessories, and equipment specially designed or modified for the foregoing. And that's where you catch an F-18 bolt that's been shortened by 1/8 of an inch. Now, I don't claim to be an expert on military ordnance or military equipment, so I'm not the one making the decisions on this. But the State, Defense, and Commerce departments have gone to the military services, who are the experts, and said, we need your help. We want you to take each of these categories of the U.S. munitions list and take that basket catch-all category, and we are going to let you keep on the U.S. munitions list anything you think, with a straight face, is significant enough from a military, national security standpoint that it ought to remain subject to the very tight controls administered by the Department of State. The only hitch is no more basket categories. If you want it controlled, you have to write it down. All the parts and components that the services are writing down are going to stay on the munitions list. But what they don't write down is going to be transferred to the jurisdiction of the Commerce Department. I want to stress that it's not going to be decontrolled, but it is going to be transferred to Commerce jurisdiction. And again, we have considerably more flexible licensing policies. I mentioned the fact that we have a 25% de minimis rule. That's going to be important. As well as license exception, strategic trade authorization. That's also important. Another difference between the two sets of regulations that will reduce the number of licenses, so it won't be one-to-one for items moving from state to commerce, is that the State Department requires a purchase order each time you want to get a license. And we don't require that. We require you to identify who the end user is and what the end use is. And we often investigate both of those. But we don't require a purchase order each time. And that's going to help get us around the problem that I've talked about with some very small manufacturers, medium-sized manufacturers. One fellow who makes satellite parts told me that when he gets licenses, it's often a $200 part, for which he has to shell out an additional $250 to the State Department for a license. You do pay it at the end of the year, but they keep track, and you have to pay it. For well or for ill, the statute under which we operate forbids us from collecting fees, although plenty of people in our budget office would love to change that. I'm not sure it's going to change anywhere in the near future. So what we're going to have is a much more specific U.S. munitions list. And we hope that that will reduce very substantially the number of cases that need to be brought under the commodity jurisdiction procedure, which is often very contentious and very time-consuming. Again, this is not a decontrol. Let's say I've talked about STA already. I know it's late in the day. I don't want to protract this any more than I need to. We've published 5 sets of proposed rules so far in the Federal Register, 5 new write-ups of the categories on the U.S. munitions list, along with the corresponding proposals for how Commerce will control these items when they come to our agency. And that's going to be on a new 600 series in the Commerce Control List. So they are going to be separated out. In addition, the State and Defense Departments issued a report last week on satellites under the provisions of Section 1248 of the 2010 Defense Bill. In the late 1990s, there were charges that Hughes and Loral had assisted the Chinese government in figuring out why a rocket had failed to put a satellite into orbit. And partly in response to that, the Congress decreed legislatively, and that's different from the other categories, legislatively, that satellites, commercial and military, should all be controlled as defense articles, all be controlled by the State Department. So this proposal under Section 1248 is to give the President the authority to move commercial satellites back to the jurisdiction of the Commerce Department. For all the other categories, and there are about 18 of them, we do not require the approval of the Congress, although we'd very much like to have them approve it in an informal sense, and very much like to have them agree that we're doing the right thing. But the law that Congress passed, that Congress wrote, the instructions that Congress has given us, is that they are entitled to a report in advance of what we propose to move from the U.S. munitions list and what we propose and how we propose to control it when it comes to the Commerce Department's jurisdiction. But after a 30-day waiting period, we're permitted to go forward. Again, we are not looking to make this a struggle with Congress. There are already enough struggles with Congress not to go looking for more. But we do have that right under the Arms Export Control Act. And the President is very much committed to this program. So there are 5 categories out. The 1248 satellite report also had as an attachment the proposed rewrite of Category 15, which is the satellite category of the munitions list. In the next week or so, we're publishing the proposal for Category 5, which in Washington speak is energetic materials, which I call explosives. But coming up are firearms, parts and components for firearms, ammunition, toxins, auxiliary equipment, training equipment, protective personnel equipment, and 2 of the hardest, electronics and sensors and night vision devices. Ed spoke in introducing me about the new rules on internet interference that the President issued the other day, and underscored the importance of industry participation in making sure that the administration gets it right. Although I'm more inclined than I was 2 years ago to think that the government always gets it right, I'm willing to admit that we don't always get it right. And I spent 29 years telling the government why it hadn't gotten it right. So because of that, we are very anxious, almost desperate for public comment on these often highly technical proposals. We think we know what's what with your products, but you may know a lot better what's what with your products. And we think we know what goes on day to day in the exporting process. But you and the people who handle exports for you and export documentation also know it pretty darn well. And we are very anxious to have public comments. We've gotten terrific public comments on what we've published so far, and they've really had an effect as we move toward final rules. Just to turn back to the satellite industry as an example of how export controls can affect our defense industrial base. When the satellite controls were moved by Congress from the Commerce Department to the State Department in 1999, the U.S. satellite industry had 75% of the world market. Today it's 23%. We hope that this, like the parrot in The Fish Called Wanda, that they're not dead, they're just sleeping, and that getting satellites, commercial satellites moved back to the Commerce Department will help revive that industry. And again, as well as focus our controls on what really counts. As we work to rebuild the U.S. munitions list and reform the Commerce Control List as well, which is also not perfect, although it's more specific than the U.S. munitions list, we're taking a number of other steps to resolve potential operational issues. Last week, we published a rule establishing a new export control classification series called 0Y521, which is designed to cover certain items that are not listed elsewhere on the Commerce Control List. It's really a temporary holding classification. And the reason we've established it is because we frequently have had situations where we're discussing a commodity jurisdiction case with the state and defense departments, and everyone around the table agrees that the item really doesn't have to remain on the U.S. munitions list, or it shouldn't have been on the U.S. munitions list in the first place. And the next question invariably is, well, if we transfer it to the Commerce Department, what's the classification going to be? How tightly is it going to be controlled? And often the answer is what we call EAR 99, which is really the lowest level of control. And people around the table immediately go, and the result sometimes has been that the item stays on the munitions list, even though everybody agreed that really isn't the best place for it. So this new intermediate category will allow items like that to be transferred to our control, but not simply open the door and let them go. We envisage this as a temporary holding area while we discuss with the other agencies and with the multilateral regimes, which often control these items, how they ultimately should be controlled. We're also going to be publishing for comment, I hope in the next couple of weeks, a proposed transition rule that describes how you handle the situation where you are an exporter or a manufacturer of items on the munitions list, and some or all of what you make or sell is being moved to commerce control. So we're going to deal with issues like what you do with your existing State Department licenses, how to handle, how long you have to transition to the commerce controls, existing State Department approved agreements like manufacturing license agreements, and technical assistance agreements. We appreciate that it takes a long time to do some of this. For some companies, it's tens of thousands of reprogramming of the designation and the classification of parts. So we are going to try and give an adequate amount of time. We and state are each going to publish a rule on this, I think, in the next month or so. And again, very important to have your comments, because if we're going to screw you up, now's the time to stand on your hind legs and holler. One of the problems in the many different sets of rules and regulations we have, and there are two different lists, 3 different sets of rules, if you count the Treasury Department's embargo rules, is that we don't have uniform definitions. So identical or very similar phrases are defined differently or applied differently by the 3 agencies. Indeed, there's even been a problem with applying the phrase specially designed differently between 2 different divisions of the Bureau of Industry and Security, my bureau. So one of the other things we're trying to do is harmonize definitions. In July of last year, we published a proposed definition of specially designed. It got a lot of comments. We're going to publish it in proposed form again, I hope, very soon. Aside from list review and the regulatory items I've been talking about, we're doing a number of other things to make the export control system a little more user-friendly and a little less over-controlling. We've established an information triage unit, which is a place where all the agencies who are active in the licensing and enforcement of export controls will be able to have access to and exchange relevant intelligence information. Sometimes there are real disparities in who knows what, and you kind of try to hint at it over the phone, but you really can't. Then you got to find a secure phone or meet in a skiff, and it's a lot easier if we know there's one place we all can go, and as it happens, it's going to be housed at Commerce, and share intelligence information and have analysis and discussion of it. We've also established an Export Enforcement Coordination Center, which is designed to, this is a word that I think is not in the dictionary yet, but deconflict export enforcement issues. David Mills, who's our Assistant Secretary for Export Enforcement, is dying to get it into the Federal Register or maybe even into the OED, but he hasn't succeeded yet. But the idea is to make sure that we don't trip over, as enforcement agencies, don't trip over one another's work. If we get a lead on Joe Jones from Toronto, let's say, we might bring it to the table and find out that he's being investigated for money laundering by the Justice Department or something else. It's amazing how often there's sort of a cross coverage of criminal statutes when you get into one of these cases. So we're trying also to make sure we don't bust in on someone else's sting operation. That would really, it has not happened, but we want to make sure it doesn't happen in the future. Right now there are about 13 different licensing forms, even in the electronic agencies, which are state and commerce, that can be used for applying to make an export. We are trying to design a single licensing form that will be used for all the exports covered by state, covered by commerce, and also trade exports covered by the Treasury Department. I've talked about the harmonized definitions. We are also heading for ultimately a single portal. So you don't have to submit to D-Trade or to SNAP-R and figure out where it goes. Although it's interesting, I find that the people who use SNAP-R say, please, let's do it on D-Trade. And the people who use D-Trade at the State Department all seem to say, oh, for God's sake, can we use SNAP-R for this? So it makes me think that maybe neither of them is what it ought to be, and we're going to be looking harder at that. We also are about to move sometime, in Washington means this year, not this week. But State and Commerce are about to move on to the Defense Department's export licensing computer system, because currently we often have problems where licensing officers in the different agencies don't have access to the same information. So a Commerce licensing officer will be discussing a case with the Defense licensing officer and saying, well, now, but look at here in this attachment about the limitations on use of this item. And the officer at the Defense Department will say, gee, I don't have that. So then there's a delay while we get it to them. What we are hoping to do with putting everybody on the same platform for export licensing is not have that recur anymore. Before I take questions, I just want to reiterate that this is very much a national security effort. It is an effort to make things harder for the people who are questionable, for the items that are the most serious, but also to make things easier for defense trade and commercial trade with our closest friends and allies. Again, focus, interoperability, dealing with the designing out problem, and strengthening our defense industrial base. Our resources are limited. We are doing the best we can. I can assure you that the President and the administration are 100% committed to this effort. So with that, I thank you. I'll be happy to take some questions. Yes, sir.
Sir, I want to first acknowledge you for your commitment to our national security. And my colleague earlier brought up the question of, and I'm not sure if this is in your jurisdiction or not, but the idea that if we have a board member who is a foreign national, that we just can't approach certain intelligence agencies. Is that something that would be in your jurisdiction or not? Because I have a question if it is.
I'm not sure about the intelligence agency part of it. If you have a board member who's a foreign national who doesn't have a green card, that individual is subject to what's called the deemed export rule, which is that any technology showed to that individual is considered an export to that person's home country.
They do have a green card. So
okay. If they have green cards for commerce and state purposes, they're considered U.S. persons. I can't answer for the Intelligence Committee.
Okay, thank you.
Okay.
Eric,
Mr. Munyon,
thank
good
you.
to see you.
Likewise. For the folks that don't have those green cards, could you tell us if you have any initiatives coming up this year related to reducing the red tape for those folks? And then maybe as a part B to that question, with some of these things moving over from state, is that going to create more red tape for people that don't have green cards but want to engage in the technology for those now listed state parts and components?
Now, I have to stop and think for a minute whether my assumption is, and I'm in the guessing area now, that for items that are transferred to commerce, which again by definition the military has defined as not of critical military importance, will be subject to our deemed export rule, which I think is a little more flexible in states. Under the commerce rule, it's the place of last permanent residence that applies. So if you have someone who was born in India but who is a permanent resident in Canada, for example, we would treat that person as Canadian. For items that remaining controlled under the U.S. munitions list, they will look at the broader picture, and therefore it can get a lot more complicated and occasionally runs into trouble with home country or third country human rights legislation, and possibly including the place of birth. Now, state has issued a new rule on that. I'm not sure whether it's in final form, but at least in proposed form, I think it is in final form, trying to ameliorate some of that problem. And it seems to have eased it a bit, certainly with Canada, which has been a big problem.
Eric, let me address the President's recent decision. We did not comment publicly on it. We have for a long time been strong advocates of the government, the administration of both parties, playing a much more vigorous role trying to protect internet freedom around the world. Been very frustrated that the rest of the world seems to have been following a Chinese-type model, evolving in that direction, and it's very troubling with both economic and political consequences. So we didn't comment. In some ways we would have, because I don't really want to discourage attempts to find solutions and to get the government more involved. But there was language that we heard about that was reported that frankly is very troubling. We've experienced this language in other settings, and where the proposal talked about directly or indirectly and facilitate. You put those together and you can get anything. Now, it's applied to Iran, and Syria is more limited. Okay, I don't want to say
it's not just Iran and Syria, it's named parties in Iran and Syria.
What?
It's named parties in Iran.
No, I understand. But it's a precedent of using such sweeping language. And you and I, for years, and Jim, we dealt with the different philosophical concept of, do you do spear fishing or do you get a big net and then let people go? And that kind of language is very much of a big net. To say directly or indirectly do something to facilitate, I mean, I can make a case for almost anybody in that context. So, again, I may not care about Syria, I may not care about Iran, but if that language becomes the model going forward and you get active with other countries, as I'd like you to, boy, I think we're going to have a big problem. So I just put that out there as a caution.
I hear you. I appreciate it. We have some involvement in this process, but it's principally an OFAC.
That says a lot.
This is an OFAC, but this is an OFAC order, and they're administering it. I would urge you to talk to them and communicate this to them, and then let them know you're troubled by it. And we had a very marginal involvement in this. We got to kibitz a little. That was it.
Elbow your way into it.
Say again?
Elbow your way into it.
Well,
you've got a lot of experience on the problems of that kind of broad language, and frankly,
yeah.
it will get the administration is trying to do something very positive. It's going to get them in trouble, and I think it's worthwhile being the one to help warn them that they're going down a dangerous. And the people they want to help are going to be the most critical. So.
I'm happy to take that. I will again underscore that it is at least not a country embargo. It's specific to the listed parties, so that narrows it quite a bit. And but it's true. It's facilitating those parties, and that could be a long reach. But I hear you. Thanks.
I'll ask you a question, I guess. Oh, I'll ask you a question. I think it's great what you're doing with the ammunition for the space business especially. I used to work with Patricia Cooper, who I know worked with you a lot.
Trying to make her day.
Yeah, I was a board member with her, so we used to get your stuff and we had to comment on them, so good job.
Thanks.
It's taken a long time, but good job.
Dog is walking on its hind legs.
Yeah.
That's the amazing part.
I was a little surprised, I guess I didn't know, I was educated today by you, that the commercial satellite business would all be considered off the ammunition list, only on the commerce list, considering, when you look at military and commercial satellites, there really is no difference on the bus part of those aircraft, on the spacecraft, I mean. It's the payloads that are only unique. So there is a lot of intelligence, I guess, that goes into the bus part of a satellite, and I didn't realize we were taking the whole commercial business and saying all of it goes to commerce. I thought it was being dissected more.
It probably is being dissected more. I'm using shorthand. If you look at the 1248 report, it speaks about military and intel satellites are going to stay with defense. And then there are about 2 pages of technical parameters about which other satellites, communication satellites primarily, will be allowed to come to commerce if the president gets this authority. So it's my mistake in using commercial as a shorthand. The actual proposal, which is attached to the 1248 report, is very specific, painfully specific. I don't do nanometers as a rule, and it's, that kind of stuff. But you should look at it, and by all means, this is about to go the legislative route. Congressman Berman has a bill. I understand that Senator Bennett may be introducing a bill in the near future. And so it's going to be in the legislative process, and obviously the Congress has every right to take its own look and reach its own conclusions about where the line should be drawn. So I should retract the use of the word commercial. I was using it as shorthand.
How about the communication industry? I mean, are we doing anything for the comm industry as far as military comm goes? The gear that goes into F-18s and other things like that that are actually
Every
comm
single
devices?
category is being looked at,
All of it,
and we're
okay.
publishing them one at a time, and I assume that would mostly be in Category 11, which is electronics. That is a hard one, but it's a big one, and we're hoping to get that out in the next 60 to 90 days in proposed form, and for Pete's sake, look at it, comment on it, tell us what we got right and what we got wrong. Yeah.
Thanks for coming, sir. This is
My pleasure.
a topic I wouldn't realize I'd be so interested in, but thank you very much. I learned something today about your Ron Yokobitis, Austin, Texas data foundry, about encryption rules that I had forgotten we had. And a lot of the internet today, because of all the snooping, the lack of privacy, the lack of choice, and brought, that there's a lot of the net is going encryption between your iPhone over this wireless link here, which can be snooped by, is going encrypted, and people are encrypting inside a VPN tunnel. Is this raising alarms for export controls, or are some people innocently in business and violating some of the encryption rules for export controls? But there's quite a bit of encryption going on, more than just your usual SSL IPsec included in a router, but there's other private encryption schemes so people can privatize from the snooping of the carriers and even the website itself.
Well, there are still substantial controls on encryption. They're not on the use of encryption, they're on the export, whether electronic or in some other form, as firmware, whatever, of encryption. So it may be there, and they're still quite substantial. We have reduced them a lot, where you still, for example, many types of encryption, you still have to report to the government before you export them, but there's no longer a 30-day waiting period. As long as you report it before you ship, the government has the information it would like to have about what you're exporting. I dare say this is a subject we tend to leave to the National Security Agency for pretty obvious reasons. They're the experts within the government. I mean, we issue the licenses, but they're the experts on encryption. We sometimes fight with them about where the line should be drawn, but ultimately they're the experts. That's only a half answer, but it's all I can give you.
Eric, let me raise something. You mentioned a very important rule, the Minimis Rule. And that stops a little something from jamming up a major project. Well, I know you sit in the Secretary's inner council, and you have your colleagues there from the intellectual property world and the patent office. And I'm not being facetious, really, but the truth is, boy, export to them some of these concepts, because you know, we estimate between 20,000 and 100,000 patents play here. Any one of those can theoretically result in injunctions, are the basis for massively expensive lawsuits. It is misused, the patent system. Used properly, it's a great system. Misused, and the way it's evolved, it's being misused a lot, is a real drain on innovation. And frankly, like I said, I'm kind of stretching a little here, but the truth is that we'd love to see some creative thought of how one little, maybe not very significant patent can tie up a whole product line and hundreds of millions of dollars in trade and export. And frankly, the current players aren't solving the problem, so if you've got any expertise, but at least to I think, sensitize the Secretary and other people at that level that this, in spite of the fact, I mean, everybody praised the patent bill that got passed. We didn't. And a lot of people in the industry really understood it didn't do anything much.
Does first to file help at all with the
It's
hidden
not the
patent problem?
significant.
That's all I know about patents. You've got it.
The patent bill that was in the House 4 years ago, 5 years ago, was a great piece of legislation. By the time we got something enacted, all of the positive parts of that, or many of the positive parts, were stripped away. So what we did not get a real patent reform bill, and it's hard to get major legislation through in this area again, I'm sure. But to the extent the executive branch can try to look for ways to get us out of the patent mess we're in, it would be welcome. And the concept of the minimis of involvement. Somehow, so patents, and I'm making this up as I go along, I hadn't thought of it, but, you know, maybe patents, when they're granted, can also be given a criteria of probable importance, which can maybe be challenged later. But, I mean, I have had general counsels of major companies, one after another, to talk about the resources they're devoting to filing patents. And they're saying they know they're filing junk patents. They're doing it defensively, and they're doing it just to be extra careful that they've got everything. But many of those patents that they get granted are not measures of real innovation and ingenuity. So, you know, get into the patent world.
Well, it certainly falls into the category of clogged systems. There's no question about that, although our patent office is working very hard to reduce the backlog, and I think with a lot of success. But it doesn't mean that the criteria can't be re-examined.
Well, thank you very, very much. It's
Thank you.
great to have you.